In Judge Judy's courtroom, the air was sharp and honest as usual. The case this time wasn't about love or betrayal. It was about money, time and trust between a client and his lawyer. Mr. Price, a man caught in the storm of a failing marriage, had hired Mr. Belmer, an attorney from Washington State, to represent him. Divorce cases are emotional hurricanes, and Price just wanted someone to help him through the legal maze. On April 4, 2012, he handed Belmer a $3,000 retainer, half of which, according to their written agreement, was non-refundable. What he didn't know was that this retainer would soon become the center of a courtroom showdown. Judge Judy's tone was but cutting. "Mr. Belmer, when were you admitted to practice law?" "In 1990, Your Honor," he replied, standing straight, voice steady. "No suspensions?" "None, Your Honor," she nodded. "Good. Now let's talk about this $3,000. According to the retainer agreement, $7,500 was non-refundable, and the other half would be billed at $243.75 an hour for actual work done. Simple enough, on paper, but in life, even legal contracts twist when trust fades. Mr. Price, nervous but clear, said, "Your Honor, I signed the agreement, but I never received a copy." "That's not your biggest problem," Judy said. "Your problem is whether you got the work you paid for." Mr. Price claimed the lawyer barely did anything. One short consultation, a quick coffee meeting, and a single 1-hour court appearance. That was it. By his math, Belmer had done maybe 2.5 hours of work. For that, he figured the lawyer earned about $610, not $3,000. Judge Judy counted on her fingers. Half-hour first meeting, 1 hour in a coffee shop, 1 hour in court. That's 2.5 hours total. Correct? Yes, Your Honor. She turned her gaze to the lawyer. Mr. Belmer, is that about right? The lawyer shifted uncomfortably. I did more work than that, Your Honor. Much more. In fact, I did over $3,000 worth. Judy's eyebrow rose. Show me. That's when the silence in the courtroom grew heavy. Belmer had no ledger, no billing log, no record of his hours. Just words. In Judge Judy's court, words without paper mean nothing. "You're an attorney," she said. "You should know better than anyone. If you charge by the hour, you must justify your hours. Where is your record?" "I have a draft bill on my computer," he said weakly. "But Mr. Price told me he never wanted to hear from me again." Judge Judy leaned forward. "And that's why you came to court without proof. You expect me to believe you worked $3,000 worth of hours based on a conversation." The audience chuckled quietly. Everyone knew what was coming. Belmer tried to defend himself. He said that after their first court appearance on April 12, 2012, the domestic violence protection order against Price had been dismissed thanks to his negotiation. That, he claimed, was value. "I got his petition dismissed, Your Honor." The opposing attorney agreed to drop it. Judge Judy nodded. "So, you achieved a good result for that case?" "Yes." "But he also hired you for his divorce case, correct?" "Yes, Your Honor." "And you didn't finish that one?" "No, Your Honor. Mr. Price discharged me on April 17th. He called and said, quote, 'I never want to hear from you again.'" Judge Judy smiled dryly. "That sounds like a pretty clear firing, Mr. Belmer." "Yes, but I still prepared for his settlement conference the next day, just in case." "That's your problem." Judy interrupted. "He fired you on the 17th. You don't get paid for working on a case after being fired." The lawyer's defense crumbled faster than a cookie in hot coffee. Judy looked down at the retainer agreement again. It said clearly, $243.75 per hour. No mention of a maximum cap. No promise that the total would never exceed $3,000. No handshake exceptions. "You're a lawyer," she said sternly. "You know better than to claim you changed the terms verbally. If your client can't do that, neither can you." The audience leaned forward as Judge Judy picked up her pen like a sword. "Now let's be clear. 2.5 hours of work at $243.75 equals about $610. You were paid $3,000. Half was non-refundable, leaving $2,500 potentially owed. You didn't prove more work beyond those hours. You get paid for what you can prove, not what you feel. She looked straight at Mr. Price. You're not getting the full $3,000 back. You knew $2,500 was non-refundable, but you'll get back what he can't justify. Then she turned to Belma. You came here with no record, no bill, no timesheet. For a man who's practiced since 1990, that's sloppy. Judgment for the plaintiff. $20,400. Her gavel dropped with that iconic thud that ends all arguments. Step out.